A contract is a legally binding agreement between two or more parties that outlines the terms and conditions of their relationship, sets forth the rights and obligations of each party, and establishes the framework for their interactions. It creates a legal relationship that can be enforced by law if any party fails to fulfill its agreed-upon obligations. Contracts can cover a wide range of transactions and relationships, including business deals, employment agreements, sales of goods or services, leases, and more. Termination of contract is an act that may occur wherein a contract can be legally terminated before the contractual duties have been fulfilled. Termination of a contract involves ceasing the rights, obligations, and responsibilities of the parties involved as stipulated in the contract terms. In this episode of EssAnnPee Knowledge Series, let's discuss on the topic, How to Terminate a Contract, authored by Panigrahi. Certified PMP, Authorized Training Partner, ATP, Instructor, PMI, USA, Fellow Institution of Engineers, FIA, Chartered Engineer, Certified Lean Six Sigma Black Belt, Certified Lead Auditor IMS, Z Consultant, GST and International Business and Projects Consultant, Corporate Trainer, Mentor and Author, Life Member Indian Society for Training and Development, ISTD, National Council Member, IIMM. Termination of a contract. Contract termination refers to the process of ending a legal agreement between two or more parties before the contract's originally specified completion or expiration date. When a contract is terminated, the parties are released from their obligations and duties outlined in the contract. Contract termination can occur for various reasons, including mutual agreement, breach of contract, failure of performance, change in circumstances, or the presence of specific termination clauses within the contract itself or other specified reasons. Termination of a contract involves ceasing the rights, obligations, and responsibilities of the parties involved as stipulated in the contract terms. The terms and conditions for contract termination are usually outlined in the contract itself or governed by relevant laws and regulations. Terminating a contract can have legal, financial, and practical implications, so it's important to follow proper procedures and seek legal advice if needed to ensure that the termination is executed correctly and fairly. It's important to note that contract termination should follow the terms and procedures outlined in the contract or according to relevant laws and regulations. In cases of dispute or uncertainty, legal advice might be sought to ensure that the termination is carried out correctly and fairly. Now let us discuss how to terminate a contract and understand possible circumstances leading to termination a contract. 1. Termination by notification. This method involves one party who wants out of the contract notifying the other party of their intention to terminate the contract as per the terms specified in the contract itself. The contract usually outlines the notice period and conditions under which termination can occur. The notice contains the reasons and terms under which you are permitted to terminate the agreement. A notice of contract termination creates a record that you notified the other party about the cancellation and the end date. This must be in writing, giving advance notice as per contractual terms and within a certain number of days from when they want to end the contract or when it will be automatically renewed. Termination clauses may generally include fees for early termination. Be sure you are willing to pay the penalty before using the clause and terminating the contract. Examples. A company hires a contractor to build a website but later decides to terminate the contract by providing the contractor with a written advance notice as stipulated in the agreement. A freelance writer giving 2 weeks notice as required to a client before terminating the contract. A lease agreement might allow either party to terminate the lease with 60 days written notice. A common termination clause says that the person who wants out of the contract must notify the others involved of his intent to do so. Two. Termination due to impossibility of performance. If it becomes objectively impossible for one or both parties to fulfill their obligations due to unforeseen circumstances, the contract may be terminated. Some contracts include force majeure clauses that allow termination if unforeseen events beyond the parties' control make contract performance impossible. If one of the parties is unable to perform the obligations due to some impossibility, circumstances that are beyond his control, then that party has a legal right to terminate the contract. For example, a company may hire and sign a contract to have a public speaker talk at a company event. Once the public speaker fulfills his duties agreed upon in the contract, it is called performance. However, if the speaker is seriously injured and no one could replace him, that would be impossibility of performance. Similarly, in case of death of a keyman musician who signed a contract to perform at a concert, now making impossible for the event to take place. Another example, if you agree to sell your boat tomorrow and tonight a hurricane comes, an unforeseen event, and damages it beyond repair, force majeure, the sale becomes impossible, and both parties can be excused from the contract. Some more example, impossibility excusing one's obligations under a contract, where a party was contracted to paint a house, but the house burned down before the party could perform. Or a construction contract cannot be completed due to a natural disaster destroying the work site, the parties may be released from their obligations. The site of constructing a building subject to a contract is seized by government before work begins, the contract could be terminated due to the impossibility of performing the agreed upon task. 3. Termination due to frustration of purpose. This occurs when unforeseen circumstances make the original purpose of the contract irrelevant or impossible, impractical or pointless. In such cases, the contract may be terminated. Frustration of purpose occurs when the reason behind entering a contract goes away. To be able to terminate a contract based on frustration of purpose, the purpose of the contract must be known by all parties involved. For instance, if a person rents a venue for a wedding reception and the wedding is called off, the venue is no more required, the contract might be terminated due to the frustration of its purpose. Some other examples. A political party leased 10 vehicles for 5 days for parade and procession against certain grievances, but due to sudden changes in local laws, procession in a particular route and area is not allowed due to regulations. The parade is cancelled. The purpose of the contract, parade or procession, is frustrated. The contract may be terminated. Mr. O, man in Oman, enters into a contract with Mr. Bharat of India 2 years back to pack food items in aluminium foils for a period of 5 years. After 2 years into the contract, now Omani laws are passed making it illegal to pack food items in aluminium foils. With the ban on aluminium foils, Mr. Bharat no longer has a reason to continue with the food packing. The contract can be terminated. What effect does frustration have on a contract? If frustration occurs during the contractual relationship, the parties can be discharged from their agreement immediately. However, it is important to be aware that the contract is not terminated from the beginning of the agreement, but rather from the time of the frustrating event. It is good practice to specifically state in the contract such clause for termination due to frustration. The doctrine of frustration can also be imposed when one of the parties has declared for bankruptcy or due to death. Additionally, terms inserted into the contract which prevent the agreement from having effect, or a specific occurrence has transpired which causes the agreement to be terminated are also additional means in which the doctrine of frustration can be imposed. 4. Termination due to breach of contract. In a contract, both parties have a duty to perform in a contract. Breaches may occur where one party fails to perform their duties as outlined in the contract, blocks you from fulfilling your duties, or when one party violates the terms of the contract. Therefore, if a party fails to perform their contractual duties, then that party has breached the contract. If one party fails to fulfill his end of a contract, that lack of performance, i.e. breach by that party, may allow the non-breaching party to terminate his end of a contract. When breach occurs, the non-breaching party may be able to recover losses caused by the breach. This usually occurs after giving notice of the breach and allowing an opportunity to remedy it. For example, if a supplier fails to deliver goods by the agreed upon date and time as essence of the contract, the buyer might terminate the purchase contract. Some other examples. Consider a situation where a retail store contracts with a supplier to provide a certain quantity of electronic devices that meet specific quality standards. If the devices consistently fail to meet those quality standards, leading to customer complaints and returns, the retail store might decide to terminate the contract due to the supplier's breach of providing products of the agreed upon quality. Suppose there is a contract between A and B. The contract stipulates that Company A shall make monthly payments upon the completion of each milestone. If Company A fails to make the agreed upon payments for several consecutive months, Company B might consider this a material breach of the contract and could terminate the agreement due to the breach of the payment terms. If someone was contracted to paint a wall, the other party was contracted to pay him for his service. If the painter fails to uphold his part of the contract, painting the wall, then the other party can legally terminate his side of the contract to pay for the service, because the painting is a condition of the payment. 5. Termination by convenience or mutual agreement. Parties may agree to terminate a contract for reasons not related to breach or legal obligation. This could be due to changed circumstances or a shift in priorities. This is often termed termination for convenience. The contract may have contained a specific provision stating the conditions under which it may be terminated. Such a provision is known as a termination clause, and is enforceable if both parties agree to the termination terms and may cancel the contract by mutual agreement at any time. For instance, suppose a consulting firm is engaged to provide a 6-month project for a client. However, midway through the project, the client's priorities shift or due to changes in business strategy, and the service is now no longer required. Both of them decided to discontinue the project. The consulting firm and the client might decide to terminate the contract by mutual agreement, recognizing that the project's original objectives no longer align with the client's needs. Another example, imagine a situation where a business rents office space under a lease agreement for a duration of 2 years. After 1 year, the business experiences significant changes in its operations and decides to downsize its office space requirements. The business and the landlord might mutually agree to terminate the lease early without any breach of contract. This benefits both parties, as the business can reduce costs, and the landlord can find a new tenant sooner. 6. Termination for instances of mistake, fraud, or misrepresentation. If a contract was formed under conditions involving mistake, misrepresentation, or fraud, the contract may be terminated, since it was not formed according to sound contract principles. Fraud, a deceptive or fraudulent contract, is not legal and will not be upheld in the court. Mistake, if a mistake is made within the contract, it may be dismissed. Misrepresentation, like fraudulent contracts, agreements cannot be based on misrepresentation. For instance, one party cannot fail to state all terms within the contract. Void contracts are unenforceable by law. Even if one party breaches the agreement, you cannot recover anything because essentially there was no valid contract. If one party enters into a contract based on false information, mistake, or misrepresentation by the other party, the injured or aggrieved party might have grounds for terminating the contract. For instance, if a car dealer misrepresents the condition of a vehicle being sold, the buyer could terminate the purchase contract. Another example, a house owner is selling his house and advertises it as having a 2-car parking and garage provisions. However, upon purchasing the property, the buyer discovers that there is only 1 garage, not 2 as promised and advertised. The buyer may have grounds to terminate the real estate contract due to misrepresentation of the property's features. 7. Bankruptcy or insolvency. This can significantly impact the party's ability to fulfill its contractual obligations, which may necessitate the termination of the contract to protect the interests of the non-insolvent party. If one party goes bankrupt or becomes insolvent, it might lead to the termination of contracts involving that party. The legal implications and procedures for contract termination due to bankruptcy can be complex and may vary depending on the jurisdiction and the terms of the contract. Imagine a manufacturing company that relies on a key supplier to provide essential raw materials for their products. If the supplier declares bankruptcy and is unable to fulfill its obligations, the manufacturing company might have to terminate the supply contract due to the supplier's insolvency. Another example. A business rents commercial space under a lease agreement. If the landlord goes bankrupt and the property comes under the control of a bankruptcy trustee, the business may need to terminate the agreement as ownership changes. 8. Death or incapacity. If a contracting party passes away or becomes incapacitated, the contract might be terminated since they can no longer fulfill their obligations. Suppose a partnership agreement exists between two individuals who run a successful consulting firm. The agreement stipulates that the partnership will dissolve in the event of the death of either partner. If one of the partners unexpectedly passes away, the partnership contract might be terminated automatically, leading to the winding down of the business. Another example, imagine a scenario where a famous musician is contracted to perform at a music festival. The contract includes provisions specifying that if the artist becomes incapacitated and unable to perform, the contract can be terminated. If the artist suffers a serious injury that prevents them from performing, the festival organizers might have the right to terminate the contract based on the artist's incapacity. Please note that if the performance is fulfilled as per contract or on the expiration of the contract term, the contract comes to natural end. Once both parties have fulfilled their obligations, the contract is considered as closed. When the contract has a predetermined end date, it closes automatically at the end of that term. For example, a one-year service contract ends after 1 year. These are generally not treated as termination. There is no need for termination procedures to follow. Remember that the specific terms and conditions set out in the contract itself, as well as the governing laws under the applicable jurisdiction, will play a significant role in determining how a contract can be terminated. It's always advisable to consult legal counsel when considering terminating a contract to ensure you are following the correct procedures and protecting your rights. What happens when a contract is terminated? When a contract is terminated, it initiates a series of actions and legal consequences that vary based on the terms of the contract, applicable laws, and the circumstances of termination. If a contract has been terminated, generally one party has legal recourse against the other party that breached the contract, unless the parties agreed to terminate the contract and release one another from their duties. Here's a point-wise brief on what typically happens when a contract is terminated. 1. Notice of termination. The party initiating the termination usually provides written notice to the other party, indicating the reasons for termination and referencing the specific contract clauses that justify the termination. 2. Legal review and rescission. Both parties might review their legal rights and obligations upon termination, considering potential legal consequences, and assessing whether the termination was done in accordance with the contract terms and applicable laws. Rescission is a remedy utilized by the courts to terminate a contract when the parties enter into a contract because of mistake, fraud, undue influence, or duress. Rescission is also referred to as the cancellation or overturning of a contract. 3. Return or settlement of goods and services. Depending on the contract terms, any goods or services provided up to the termination point might need to be returned, settled, or compensated for, as per the contract terms or negotiation between the parties. If any property, assets, or materials were exchanged or borrowed or used during the contract as part of the contract, the terminated parties might need to return these items to each other, as specified in the contract or through negotiations. 4. Financial settlement. Financial matters related to termination, such as outstanding payments, refunds, or compensation for work completed, compensatory damages for non-performance or punitive damages, are addressed. Any amounts owed by one party to the other are typically calculated and settled. 5. Property and information exchange. If applicable, the parties might need to exchange property, data, intellectual property, or confidential information that was shared during the course of the contract. 6. Cessation of performance and termination of obligations. Cessation of performance means both parties cease performing their obligations under the contract. This includes stopping the delivery of goods, provision of services, or any other obligations outlined in the contract. The contract might also outline specific obligations upon termination, such as return of confidential information, removal of branding, and other post-termination responsibilities. 7. Dispute resolution. If there are disputes arising from the termination, parties might engage in negotiations or follow the dispute resolution mechanisms outlined in the contract, which could include mediation, arbitration, or litigation. 8. Restitution and remedies. If one party breached the contract, the non-breaching party might seek remedies, restitution, or damages as outlined in the contract or by applicable laws. 9. Reformation. Reformation occurs when a court reforms or changes a contract to correct any inequities. Reformation is utilized by courts to rewrite an otherwise inequitable contract, instead of setting aside the entire contract, or 10. Specific performance. Rarely a court might order specific performance, meaning that one party will have to perform their duties under the contract. Often, specific performance will only be ordered where money damages are not adequate to compensate the innocent, non-breaching party. 11. Liability and indemnification. The parties might need to clarify any liability arising from the termination, including potential indemnification for losses suffered due to the termination. 12. Effect on subcontracts. If the terminated contract is part of a larger project involving subcontractors, the termination might trigger corresponding actions in those subcontracts, depending on the relationships outlined in the contracts. 13. Post-termination clauses and transition planning. Contracts often include clauses that continue beyond termination, such as confidentiality, non-compete, or non-solicitation clauses. These clauses might still apply after the contract ends. In some cases, contracts might require the parties to work together during the termination process to ensure a smooth transition. This could involve sharing information, assisting with the transfer of responsibilities, or helping with the handover of projects. 14. Final documentation. Both parties might sign an agreement or document confirming the termination and settling any outstanding matters. Proper documentation of the termination process, including notices, communications, and actions taken, is important to mitigate any potential legal disputes in the future. (15) Lessons learned. Parties might review the reasons for termination and the events leading up to it to learn from the experience and avoid similar issues in the future. It's important to note that the specifics of what happens when a contract is terminated can vary widely based on the type of contract, its terms, the jurisdiction's laws, and the negotiations between the parties. Legal counsel and proper documentation are essential during the termination process to ensure that rights and obligations are upheld appropriately. Thanks you. Do you find the presentation informative and useful? If yes, then click like and also subscribe the channel for free to receive updates. For more details, contact Panigrahi at the below contact details.